Yes.
Please be seated. Thank you.
We are on the record.
All right, let's go ahead and set forth our appearances.
Good afternoon, Your Honor. Teddy Parker on behalf of the plaintiff.
Robert Eglin on behalf of the plaintiff, Your Honor.
Counsel plaintiff.
Brianna Switzler for plaintiff.
Tyler Watson and Eric Freeman for the defense.
Mr. Freeman? All right. Okay. And Mr. Parker, you ready to continue, sir?
I am, Your Honor.
Okay.
Your Honor, we're going to need to take a break after Mr. Parker's, I got a lot of setting up to do.
And there's no problem with that, and I kind of anticipate that anyway.
Okay.
And Your Honor, just briefly, out of the presence of the jury, we will need to amend the verdict form based on the stipulation that we entered into regarding Ms. Boardname, but we'll work with plaintiff's counsel to get a new version to the court on that.
And that's fine.
Thank you. You said you did that? Oh, just now.
Come on, man. How do you get that? I was trying to figure out how you did that. Was that? Hold on, I'll tell you exactly.
Okay, no worries.
Key word.
Oh, yeah. That was one.
Eric did it, and I didn't want to make it apparent, so I just was there.
That's helpful.
Right, it's going to be good, right? Four fucking cameras.
Oh.
All rise to the jury. Please be seated. Thank you.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
All right, ladies and gentlemen, I hope you enjoyed lunch. And it's my understanding we're going to continue on with Mr. Parker's closing. Is that correct, sir?
That is correct, Your Honor. May I
All right.
proceed, Your Honor?
Yes, you may.
Thank you. Let's continue where we left off. Good afternoon, everyone. Good afternoon. Lunch was good? Somebody's got something in their mouth, just happy about it, I can tell. All right, you ready, Shane? So just to set the stage, this is again Dr. Alcina talking about the permanency of liver injuries. Okay, go right ahead, Shane.
Is it fair to say that hydrogen exposure can cause permanent liver injury? It's fair to say in some patients, maybe if you don't have precise histology follow-up on these people, we may not know, but that's fair to say. And it's also fair to say that you cannot rule out that each one of these patients has suffered some form of permanent injury. I mean, histologically at the microscopic level, it's one thing because everybody's focused on permanent, but we're only looking at microscopy, so how are they doing clinically is different from what's in a biopsy. And so, and I appreciate that response. But isn't that your response is another way of saying, at this point in time, in front of this jury, you can't rule out that each one of these plaintiffs has suffered some form of permanent injury, correct? Right.
All right. So I think that's the bottom line, that based upon his examination of all of the medical records for each of these plaintiffs, he can't rule it out, unlike Dr. Robert. Now, we're going to switch gears, and this is why I thought it was appropriate to take lunch, because that was probably a good breaking point. we're going to now talk about relapse, okay? And I say relapse because, you know, in terms of Ms. Bourdonnais, for example, and Ms. King, they now have incurable diseases for the rest of their lives that they'll be dealing with because of real water. That's something that there's no debate about. The court has found that to be the case. All of the doctors agree. There is no dispute on this issue. Both Ms. King and Ms. Bourdonnais have suffered incurable diseases that they will be monitoring the rest of their lives. So in terms of the science, there's only 2 articles that we're aware of that addresses that. Again, there's so little science or articles available. The first one is this nomenclature, diagnosis, and management of drug-induced autoimmune like hepatitis and expert opinion meeting report. This document came out in September of 23, just a year and a half ago virtually. And this is the Andre document. Perhaps you remember me speaking with Dr. Hudson about it. Go to page, this document actually specifically mentions hydrazine. If you could go to the summary on the same page, Shane. Right there. And hydrolysine, I'm sorry. So hydrazine is a metabolite of hydrolysine. So Shane, go to 65. No, I'm sorry, page 5. This is exhibit 119, ladies and gentlemen, page 5 of this document. So Dr. Robbins said, you know, it's unlikely, but this is the literature. 65% likelihood. Not just 51, not the butterfly on the scale. That's 65% likelihood of relapse for Ms. King and Ms. Bourdonnais. Go to diagnosis below this section, Shane. Failure or late diagnosis in both cases can result in poor clinical outcomes. So Ms. Bourdonnais and Ms. King have to look forward to now virtually every 4 years, unless they are completely being controlled by medication, which we've already learned that doesn't work, to relapses. Relapses for them means back to the hospital, means more damage to their livers. And while we're not asking for a liver transplant, because no doctor has suggested it, the doctors have not ruled it out. Dr. Alsina has not ruled it out. Dr. Hudson has not ruled it out. And so they have a realistic concern about their liver health based upon this incurable disease. And that's what the literature says. If you could, Shane, go to page 7. These are liver slides, again, showing the damage done to livers based upon this disease. And I raised this just because I wanted you to see that necrosis, the death of the liver cells, is being seen in all of these slides. And that's what's been documented in terms of Ms. Bourdonnais' liver. Go to the next page, Shane. Page 8. Oh, yeah, go to page 8, please. That's page 6. That's page 14. There we go, thank you. I wanted to show, go back up to the top right. Thank you. I wanted to show how these livers look as they become more and more injured. So this is necrosis. This picture reflects that. Acute fatty liver. 9 of the 11 patients suffer from fatty liver in this case. Steatosis is another way of saying fatty liver, by the way. And this is nodular regenerative hyperplasia. but you can see the damage on the liver, which is what has been found in terms of Ms. Diaz based on her biopsy. Thanks, Shane. So based upon this article, and we'll get to only the second article, there is a clear indication based upon peer-reviewed scientific research that Ms. Bordenave and Ms. King will suffer relapses in the future. And as it goes on, it actually becomes more anticipated that their relapses will happen. I want you to go to Exhibit 647. Clinical presentation, causes of drugs and outcome of patients with autoimmune features in two prospective DILI registries. And this is May 2023. The other one was September 2023. The point is there's very limited information, and it all came out after their treatments in 21. Go to page 2, please, Shane. One thing I wanted to show you that I don't believe we got into much is here. Shane. Fourth line down. Female sex was more frequent in AIH patients than in other groups. Which partially explains why Ms. King and Ms. Bordenave, as opposed to some of the men that we have here, got AIH. Go to next line here. It says the likelihood of relapse increased over time from 17% after 6 months to 50%. Now this is what initially was discussed. If you could go to page 4, Shane. Stop right about here. Go up a little bit more. This paragraph here. Thank you. Dealing with autoimmune features in AIH patients with an acute presentation had a higher percentage of hepatocellular damage, 84% and 81% respectively. A lot greater than the butterfly on the scale. There's an 80% chance, or 84% chance, between 81 and 84% chance that Ms. Bordenave and Ms. King have suffered liver damage. Go to same page, Shane, but we need to go to the right. And go up a little bit further. Up a little. You're going in the wrong direction. Stop right there. To the bottom of this. Right there. Perfect. Stop right there. Of 9 DILI patients with autoimmune features who relapsed, 4 were on IST and discontinued or tapered it before the relapse. The point is, even on medication, they can relapse. That's the point. And then finally, at the bottom of this page, under 3.3, Shane, patients who relapsed were predominantly women, 89%. So, not to steal Mr. Kemp's thunder, but that's not great news. First, they're females, which places them at a high risk of relapse, but also it's shown that in females, they have the highest degree of liver damage. And then page 5, Shane. Right there. Just a repeat of the likelihood of relapse. And that's what both Ms. Bordenave and Ms. King have to look forward to based on the only 2 articles on the subject that these experts are aware of. Next slide, Shane. Next slide. Go right ahead.
So these people have a lifelong condition. It may go into remission for a while. That's why I say the relapse rate is 40 to 80%. and really on the higher end, and closer to 80% in my experience in the years that I've been doing this. So these people require monitoring and treatment for the rest of their lives. They're not cured just because they go in remission. They are not cured. They are not done. Very, very high chance they're going to recur.
And that's actual medical testimony from a lifelong hepatologist. Next slide, Shane. So this is just a snapshot from 2008 to 2020. Failings on the part of Real Water and flags that they received that they had never addressed. No investigation, no testing. Next slide, Shane. So you recall Dr. Hudson. He discussed his evaluation of the FDA, Southern Nevada Health District, and the CDC's investigation and how they were able to confirm the results of Real Water and how it caused acute liver failure. Go right ahead, Shane. And now let's bring this down to Ms. Bourdonnais. Ms. Bourdonnais, born in Los Angeles, married, 5 children, devoted her life in terms of education to childhood education, and especially looking and working with special needs children. And she prioritized children with autism. That's what she was doing from 2007 to 2018, when she became so sick that she had to be taken to the hospital to address the symptomology caused by her consumption of Real Water. Next slide. She testified that she worked for the Clark County School District, and then after moving here, previously she worked for the County of Los Angeles, again working with children with autism. Next slide, Shane. And this is what she testified to, and hopefully you remember it. Play it, Shane.
What kind of work do you do? And let's go prior to your consumption of Real Water. Okay? And in fact, let's start with your education, then we'll work in that direction.
I received my bachelor's degree in family and consumer sciences with an emphasis in early childhood education. My focus has been on children with special needs, mostly autism. That's where my passion is. I work with children with autism from 2007 up until this incident.
Now, because of your autoimmune hepatitis diagnosis, are you able to go back into the school environment?
No.
And why is that?
Because my doctors were afraid of my immune system being too low to be around them, and the children being exposed to germs.
And that was your passion?
Yes.
And you lost that because of Real Water?
Yes.
All right. So her undergrad degree, the master's she was working towards, and her career is over in terms of working with children. That's it. She has a lifelong disease that will now not allow her to do what she wanted to do. Not allow her to help children, and certainly given the conditions of schools and the condition of children with special needs, that is, and I would think everyone's opinion, an admirable profession to embark upon. But that's gone for her. And what entitled Real Water to compromise her health to the point where the thing that she had a passion for, she can't do any longer. That's it. And so I took issue, and I don't know if you remember, when Mr. Johnson asked her about working in another profession now, and she's able to do it and she's okay. It seemed to suggest that because she didn't just give up, that Real Water is holding that against her. To say, well, you're fine now because you can work in some other industry. Well, that's not fine. If you want to be a chef and can no longer be a chef, how would that make you feel? If you're a professional basketball player and someone caused some injury to your knee or your ankle, like Grant Hill, and you're done, how would that make you feel? That's what happened to her. And for the rest of her life, she will not be in the school environment. And she want to be around children, which we all know, everyone who has children, they carry all the diseases. They come into the house and they just get everybody sick. That's what happens. And she can't do it. Next slide, Shane.
Now, Ms. Bonnar, let me ask you a question that may seem off topic for a second. Have you ever heard of the phrase, hope for the best, but prepare for the worst?
Yes.
And have you ever heard the phrase, pray that the worst never happens?
Yes.
And I asked that question of Ms. Bourdonnais because I knew we were about to take her through her history of going through 7 hospitals, more than, I believe, 10 ambulance rides, very close to that number, a flight for life flight. All the time not knowing what is happening. Next slide, Shane.
So you're going from smaller hospital to bigger hospital to bigger hospital.
Yes.
So you're taken by ambulance from Mountain View to Centennial.
Yes.
Is this another point in time where you're wondering how serious is your condition?
Yes. Because when I got to Centennial, the doctor, my ALT, AST, and my bilirubin were through the roof, and the doctors did not seem hopeful for me at all.
Next slide, Shane.
So you get to Centennial. What happens there?
The doctor told me that if I didn't get a liver transplant, that I would die within the next few days. He asked my husband if he had all of our affairs in order because he didn't think that I was going to make it. My numbers just continued to elevate, and I just continued to get worse and worse.
So this is a point when they're asking you to get your affairs in order, where your husband is praying that the worst doesn't happen.
Absolutely, yes.
And conversely, you're trying to prepare for the worst.
Yes.
Did you have a chance to speak with your children to let them know just how serious your condition was?
My children watched me go through this. My children are still traumatized. If I get a cold, they're looking to make sure I'm okay. It was very traumatic. I couldn't walk. I couldn't stand. I could barely talk. We thought I was dying. We thought I was going to die. I went from being a completely healthy mom within 2 weeks to thinking I was dying.
Mr. Kemp used as a comparison the comments, which is the only evidence we have in this case as to the monetary value of going through this experience, from Mr. Blaine Jones. And he compared the plaintiffs to the $10 million that Blaine Jones said he would not go through, he would not take to go through this process again. 7 hospitals, more than 7 ambulance rides. This woman went through significantly more, I will say, than Mr. Blaine Jones. And that will be reflected in what, at the end of this conversation, this presentation, of what I believe you should award her, what the verdict should be. But I want you to consider that in your mind. What he went through, 1 hospital stay, he was able to leave the hospital, and then he put on his GoFund page, versus what this woman went through. And I also want you to consider that Blaine Jones had the benefit of knowing what he was drinking. He knew about the complaints and continued drinking it. Did that bottle reflect that there were 20+ complaints on it and beware? She had no idea. None of these plaintiffs had any idea that they were drinking what's considered, based upon the evidence, a highly poisonous substance. None of them. Shane, next slide, please.
Do you have a biopsy while you're in Centennial?
Yes.
And in terms of the biopsy, do you recall that procedure?
Yes.
Can you describe that procedure to the jury, please?
They told me that they had to do a liver biopsy to check to see what was going on. I remember it was very painful, very scary. Yeah.
Do you recall why they wanted to do a biopsy of your liver?
Because they thought that I needed a liver transplant. And they wanted to test my liver to see what was going on.
When you agreed to the biopsy, did they inform you, some form of written or oral consent, that there could be complications from the biopsy?
Yes.
Did they tell you that you could get some form of infection from the biopsy?
Yes.
Did they tell you that you could bleed out because of the biopsy?
Yes.
They told you all the risks?
Yes.
And you agreed to do it?
Yes.
So she gets the biopsy, and I'm going to show you the biopsy result. This was at Centennial Hills. They realize just how bad she is. They take her by ambulance from Centennial to the airport, from the airport here in Las Vegas to the airport in Los Angeles, ambulance from there to Keck Hospital. Shane, go 2 slides ahead. So this is a refresher. Dignity Health Hospital, February 25th, 2018, Mountain View, ambulance to Mountain View, ambulance to Centennial Hills, ambulance to USC Keck, by way of also Flight for Life. She gets released on March 11th and is back in the hospital 3 days later with relapse. 3 days later. And even after that, she's back in Centennial Hospital, January 14th, 2019. Similar symptomology. Shane, go to the next slide, please. So this is what brought her to Dignity Health. 7 days of nausea and vomiting. No previous medical history. Next slide, Shane. She goes to Mountain View, nausea, vomiting, jaundice, which we all now associate with acute liver failure, and acute hepatitis, abdominal pain. Next slide, Shane. This is the biopsy on March 3rd at Centennial. And you can see here they use a 21 needle and a .018 wire for this biopsy. Next slide, Shane. The biopsy reveals, and you can see this is the biopsy report, hepatocyte necrosis, death of the cells, intrahepatic cholestasis, findings acute with hepatitis. Next slide, Shane. Based upon this information, she's recommended by the GI the patient needs to be transferred to a tertiary liver center to be seen by hepatology. I want you to consider this. They didn't ask to send her to a pathologist like Dr. Robin. They asked to be sent to a hepatologist. Next slide, Shane. You can see her AST, ALT is high, and this is again consistent with them wondering whether or not she's going to need a liver transplant. INR is also increasing, and it is worrisome for liver failure. That's what she was looking down the barrel of, liver failure. Next. So eventually, as we've spoken before, as Ms. Bourdnave has said, she got out on March 11th. She ends up going back to the hospital at MLK, and 3 days later, she goes back from there by ambulance to Keck. She's there for a while. Then ultimately, after staying in California for several weeks because they had to monitor her, gets back to Las Vegas, and it's less than a year later, she's back in the hospital, nausea and vomiting. So when Dr. Robin, a pathologist, not even a hepatologist, gets up and says relapse and remission, no chance of that happening, it was happening less than a year later for her. And she's still, at this time, on prednisone, which Dr. Hudson told you, you can't take that for so long because how much damage it does to you. So she's on prednisone over 6 months. Go right ahead, Shane. At this point, May of 2019, over a year later, she's feeling sick and it's chronic. It's not going away. Now, Ms. Bourdonnais didn't complain. She didn't whine. She tried to keep a stiff upper lip and explain to you what she was going through. But it's right here in the document. Symptoms and duration is worsening. Abdomen is in pain. That's what she's going through a year later. Next slide, Shane. She's diagnosed with autoimmune hepatitis. This is May 17, 2019, and she's advised to continue on medication to try to control it. Next slide, Shane. Her ultrasound, this is a year and a half later, October 2019, 10 to 33% hepatic steatosis. Almost up to a third in fatty liver. A year and a half from real water. So in addition to having autoimmune hepatitis, the ultrasound reveals that's the state of her liver. And then a year later, this is July 21, 2020, chronic conditions of autoimmune hepatitis, and in fact now her liver is hepatomegaly, is enlarged. She's getting worse, not better. The diagnostic tests are revealing that her liver is not improving. And this is now 2 years later. March 16, 2021, almost 3 years later, she's diagnosed with anxiety, chronic kidney disease, and autoimmune hepatitis. So when you see her and these plaintiffs upset, anxious, they have a reason to be. Do you recall Mr. Johnson discussing how we have no treating physicians here, no treating physicians talking about this? These records are from treating physicians. All of these records, every record that Mr. Kemp has shown you, every record that Mr. Eglett has shown you, these are from treating physicians. If Real Water wanted to contest, they could have subpoenaed those very same treating physicians to come here and tell you, ladies and gentlemen, that these aren't permanent injuries. They're not still suffering. Not one did they subpoena. Instead, they have their own retained expert come here, not even a hepatologist, and say to you that the injuries aren't permanent. When every article that we have, and I've shown them to you, say the other one. Next slide, Shane. Finally, in March of 2021, they're reducing her azathioprine to 25 milligrams, which has helped her joint pain and her fatigue. She's still suffering fatigue. The medications are affecting her bones because they had on 50 milligrams of azathioprine before. And before that, they had on prednisone. And like Dr. Hudson said, prednisone, you walk to your death because you feel all right while it's destroying your organs. Next slide, Jane. That's her picture. That's how much she's gone through. She starts drinking water in 2017. Symptoms start appearing February 18, 2018. Hospital after ambulance, all the way to 3 years later, and she's still on medication. An incurable disease for 3 years on medication. That's what real water has caused her. Next slide, Shane. So Dr. Hudson talked about autoimmune hepatitis and how the hydrazine in real water caused Ms. Bourdonnais' autoimmune hepatitis as well as Ms. King's autoimmune hepatitis. And he also indicated that hydrazine was a trigger behind Ms. King's myasthenia gravis. He also said that they both can look forward to relapse after 4 years. Well, they've been on medication. 3 years, Ms. Bourdonnais was on medication. Next slide. This is what the medicine tells us. This is what the science tells us. Leads to significant liver damage, leads to fibrosis and cirrhosis. Without treatment, 40 to 50% die within 6 months. We're beyond that. With treatment, 83 to 94% survive more than 10 years. We're not there yet. AIH lasts the entire life of the patient. Relapses are expected to occur, which can result in further permanent liver injuries. And what Ms. Bourdonnais' records demonstrate is her liver is getting worse every year. Hepatomegaly wasn't discovered in the original biopsy. That level of steatosis was not discovered in the original biopsy. So as time has progressed, unfortunately, her liver has become more and more injured. And that's why it was so important what Dr. Alsina had to concede. Without later biopsies, okay, you got my attention now. We good?
Yeah.
Okay. Without later biopsies, you can't say that any of these patients have not suffered permanent livers, and you cannot say that their liver damage has not progressed. An incurable disease causing further damage to their livers. Next slide, Shane. This is the National Vital Statistics reports. This is what we use to determine the expected life of someone. So we're using this. The court has taken notice of it, of course. And based upon this information, we believe that Ms. Bourdonnais is expected to last or live another 34.1 years. Next slide, Shane. So, based upon Dr. Hudson's opinions and the medical reports, and we're not saying this is going to happen, but I've asked and I've said before, preparing for the worst. So this is preparing for the worst. Her medical bills related to her acute liver failure, that should be not that way, and autoimmune hepatitis. Her medical bills, as you know, was roughly $387,000. If she has a relapse every 4 years, because of the cycle that we see, this is what that looks like over 34.1 years. That's worst case scenario. Now, hopefully that doesn't happen, but Ms. Bourdonnais only has one trial, one opportunity, which means you only have one opportunity to consider the worst case scenario. Dr. Hudson also relied on this article, this 2019 article by Grewal of autoimmune hepatitis from hydralazine led to acute liver failure and liver transplantation. Again, we're not saying she's going to need a liver transplantation, but we do know is her liver damage is progressing. That's what we know. Next slide, Jane. Dr. Hudson and Dr. Alsina agreed with this. All of the plaintiffs, including Ms. Bourdonnais, should receive twice a year elastographies to determine the progression of their liver damage. That's $2,000 to $3,000 per year. Again, we're preparing for the worst. We said $3,000. You make your own decision in terms of what you want to do with that. But we're saying $3,000 per year. And when we discuss Ms. Bourdonnais' claim, we multiply it again by 34.1, her expected lifespan. Go down to the bottom. Oh, I'm sorry, to the bottom again, Shane, I apologize. In terms of Ms. Bordenave and Ms. King's monitoring for autoimmune hepatitis, both Dr. Alsina and Dr. Hudson believe that they will have to go every 3 to 4 months. And that's an average cost of approximately $1,200 to $1,600 every year to get biochemical tests to determine the status of their autoimmune hepatitis. Next slide, Shane. So this is Dr. Alsina's opinions again. He agrees in terms of Ms. Bordenave's liver enzyme scores, what they were. He says he cannot rule out relapse, he cannot rule out liver transplant in the future, and he cannot rule out permanent liver injuries. Next slide, Shane. He also agreed that hydrazine causes fatty liver, cirrhosis, necrosis, transplants, and deaths. He agreed that Ms. Bordenave has fatty liver and hepatocyte necrosis. And he agrees that Ms. Bordenave was diagnosed with hepatomegaly. Next slide, Shane. These are all of the plaintiffs that Dr. Hudson reviewed their medical records. And you can see by the far right column, go to the next page, that 9 of 11, I think it was 9 of 11, this looks like 10 of 11, had fatty liver. That's not the national average. That is, in fact, 81.81%. A lot greater than 50%, or the butterfly on the scale. 81% of the people who consume real water that are represented here had fatty liver. Next slide, Shane. Dr. Alsina agreed that real water caused Ms. Bordenave's acute liver failure and autoimmune hepatitis. Again, he agrees with the biochemical monitoring, as well as the liver test, and there's a greater likelihood Ms. Bordenave will suffer relapse of autoimmune hepatitis. Next slide, Shane. Go ahead and play.
Is it fair to say that both Ms. Bordenave and Ms. King have suffered permanent illnesses now caused by their consumption of either water with hydrogen?
Yes, I mean, they have that autoimmune label.
I think there's more to it. Yeah, go ahead.
And so when Mr. Watson was trying to ask questions to determine whether or not there is any permanency to these plaintiff's injuries, he was asking you to make a decision or give an opinion based upon your experience and the literature, correct? Yes. But he was asking you to do so based upon the bulk of your literature and your experience dealing with drugs not including hydrazine, correct?
Right, the hydrazine has not been looked at in any of these registries.
Right. And so when you responded to Mr. Watson, your response was based on not hydrazine-specific literature, correct?
Yes.
Thank you. Because the bulk of your career, with the exception of the 50 or so patients you've seen, or records you've seen, I should say, did not suffer acute liver injuries based upon hydrazine, correct?
None of them in my career, correct?
That's right. And based upon the information you've read from, for example, or the reports you've read from Dr. Robin, he has not had any experience dealing with livers injured by the consumption of hydrazine, correct?
Correct.
So when you give an opinion based upon the permanency of the injuries to these patients or plaintiffs, in this case, the 8 that you reviewed, really the best history or the best authority we have on the subject is that hydrazine can kill, it can require liver transplants, and it can cause permanent injury to livers, correct? Human livers.
Yes.
And because there are no up-to-date biopsies, you cannot say that all 8 of these plaintiffs have not suffered permanent liver injuries for which they will need medical care in the future, correct?
Correct.
And then finally, when Mr. Watson asked you about follow-up care, because there's so little literature and so little experience from the hematology world on hydrazine and how it affects the human liver, is it fair to say, and is it medically reasonable, that all of these patients should be followed to make sure that they don't suffer any further liver injuries, correct?
They should be followed. I agree with that.
And based upon the limited articles we have, it indicates even if they appear to be normal and their symptomology has been resolved, there can still be a progression of liver injury associated with hydrazine, correct?
Sure.
And you give all those opinions so reasonably medical probability or certainty, correct?
Yes.
So, in addition to agreeing to all of that, Dr. Alsina agreed that in his experience, these patients suffering from acute liver failure suffer emotionally as well. And I believe you saw him say that by his deposition or trial testimony yesterday. But he agreed that that's what happens. They suffer emotionally, and he also agreed that they should receive future medical care for that. Shane. Next one.
Doctor, with all of these patients, would you agree that they all, as part of their treatment, have suffered emotionally going through acute liver failure?
Yes, they have.
And certainly that suffering stems from confusion that goes along with acute liver failure.
It comes from them being so sick.
Thank you. And with them being so sick and not knowing whether or not they'll have future problems with their liver, do you believe that there's a form of continuation of anxiety that goes along with that?
Yes, I believe so.
And that's in your opinion, having dealt with patients, that's an emotional, mental problem that they'll have to deal with the rest of their lives.
Yeah, I mean, each one is going to deal with it differently.
Yes, sir. Fair enough. And are you aware of the fact that these patients have been diagnosed by a neuropsychologist with a variety of emotional or mental issues?
Yes.
And would you agree that in dealing clinically with patients who have suffered from liver injuries, that's reasonable in your experience?
Okay, that patient with acute liver injuries, can you rephrase it, Mr. Parker?
Sure. And specifically, I'm talking about patients who have suffered permanent liver injuries and are required to go through these monitoring tests annually. That it comes with a certain level of emotional strain and anxiety.
Yes, I mean, I'm not putting myself in their situation, but I'm sure that they go through that.
And would you believe that it's reasonable for them to receive some kind of mental assistance, medical mental assistance from a psychologist or a psychiatrist or some form of physician who can address those concerns?
Yes.
So, ladies and gentlemen, Real Water has reached an agreement with Ms. Bourdonnais, conceding that she will need that type of emotional help. So when I show you the verdict form or our request in terms of damages from Ms. Bourdonnais, it won't have that line. There won't be any monetary figure there. As you know, she was diagnosed with anxiety back in 2021. All right. So that's not an issue. We know she suffered from it. They've agreed that that should be paid for. So we will be asking for her emotional, of course, the anxiety, everything that's going along with it, both past and future, but we're not going to put an amount for the future medical bills for that issue. Understood? Okay. Shane, go to slide 77, please. This is our suggestion. And again, this has been said before. I'm sure Mr. Watson or Mr. Johnson or Mr. Freeman or Mr. Esposito, when they get up to do closing, they'll suggest whatever they suggest. But this is a suggestion. You decide ultimately what the appropriate numbers are. So we know our past medical bills from February 25th, 2018 to September of 2021. You can go ahead, Shane, put the whole thing out. It was $387,000. We know that. That's not disputed. We're suggesting actually, because it's up to the present, for the last 7 years, $15 million. And we're suggesting that because Blaine, the only evidence we have of what the value of it is, in this case, is $10 million. Certainly, $15 million, given what she's gone through, in our opinion, is very, very reasonable. This is what he said under sworn conditions. He raised his right hand, and that's what he testified to. This is what we're suggesting. Next slide. In terms of future medicals, we know the biochemical testing for AIH, that's what that's going to cost. $54,560 over 34.1 years. In terms of the elastography for acute liver failure, the testing will be $102,300 for a total $156,860. Next slide. Future medicals. This is based upon Dr. Hudson's testimony, the concessions arrived to with Dr. Alcina, which is real waters expert, 34.1 years divided by 4, because we're saying every 4 years this is a possible event, is 8.52 multiplied by 387,392.29. You arrive at 3,302,517.27. Now we hope, again, hope for the best, but prepare for the worst. We hope that this doesn't happen. But now we know, based upon all the later diagnostic tests, that her liver is not getting better, it's getting worse. Next slide, Shane. Again, like I said before, we're not putting a number here for her medical bills related to any psychiatric or psychological care, since we've reached an agreement with Real Water on that issue. Next slide, Shane. Next slide. And this is what we're suggesting for the next 34.1 years of her life for an incurable disease, $37,510,000. $37,510,000. Yep, $37,510,000. That's correct. Again, it's our suggestion. You decide. You have to decide whether or not someone who's now contracted through no fault of her own a lifelong incurable disease, which will have an impact on the progression of her acute liver condition, and what that means for her, her 5 children, and her husband. Again, I will get a chance to speak to you one more time. One other thing I wanted to point out as a part of this, and you'll hear about this a second time, is in the event you agree that punitive damages are necessary, That process is very short. Typically, that comes right after your decision on compensatory. It lasts no longer than an hour and a half, 2 hours. So typically, it's done one right after the other. So I don't want you to think that we got another 3-week trial coming, because I don't want you guys to just run right on out of here. But that's how it works. Thank you again for your patience, your time, and I'll leave you to Mr. Eglin.
All right, thank you, Mr. Parker.
Thank you, Your Honor.
And ladies and gentlemen, we're going to take a quick recess. And remember, you're admonished not to converse amongst yourselves or with anyone else on any subject matters connected with this trial, or to read, watch, listen to any report or a commentary on the trial by any persons connected with this case, or by any medium of information, including without limitations, newspaper, television, radio, social media. Remember the prohibition. And last but not least, form or express any opinion on any subject connected with the trial until the cause is finally submitted to you. And we'll take a break.
Yes, Your Honor. All rise for the court to adjourn. So close. Jury is clear.
So Tyler, I tried to be right down the middle here.
Off the record. Mr. Eglin, you ready, sir? I am. All right.
We're on the record, Your Honor.
Okay.
Kevin on the back.
Mr. Captain, yes, he is.
Mr. Johnson's place, he's pitching. That would be good for the team over there.
I know, that's nice, isn't it?
Brand new.
Why did he decide to only do 16 miles? He's only taking 18 when he has a 16.
Back to Your Honor.
Oh, wow. You been out there before?
How far is it going?
This is all about Penny's Bay. Really? Yeah. Pardon? Yes.
How many acres?
No, usually. Some mountain kind of stuff.
Did they get the donkeys on this?
No. Everything.
Do you go by it and you go to Nottingham? Oh, so you go, all right.
I'm with you?
Yeah.
Mine's short. Mine's about 10 minutes. What's that? Butter. You working on that today?
Robert.
After this? After this? Wait, they're closing.
That's Lee. That's Lee. That's the fluff on it.
This might be the first time.
I just saw it.
There are technical benefits to doing it.
No worries. I received those from I know it's all hard. I just noticed it, so I wanted to grab it.
All right, Mr.
Please be seated. Thank you.
All right, do the parties stipulate to the presence of the jury?
Yes, Your Honor.
Yes, Your Honor.
All right, ladies and gentlemen, we're going to continue with closing arguments. Next up, Mr. Eglitz, sir. You have the floor.
Good afternoon, ladies and gentlemen. As you notice, I don't tend to walk around much, and so I'm going to be standing back here so I can see all of you at once. And good afternoon. Defense counsel, at the very beginning of his opening statement, said to you, "Here's our theme. Everybody's been waiting so long to hear it. Injustice anywhere is a threat to justice everywhere." And then he goes on to say it's a well-known statement. And then he said to you, and what it means is that whereas there have been 3 opening arguments and a lot of things said and a lot of things for you all to try to remember, is you have to remember is that I represent a client as well, and my client deserves to have justice as well. Well, that's not what it means, not even close. That well-known statement was first written on April 16, 1963 by the public figure I admired most, the man my mother marched with, Martin Luther King Jr. It was written by Dr. King while he was confined to a jail cell in Birmingham, Alabama, for simply exercising his constitutional rights of free speech and freedom of assembly. It's from a very famous and inspiring letter Dr. King wrote to a number of white clergymen who had publicly chastised Dr. King while he was in jail, calling his activities unwise and untimely, and claiming that he was an outsider with no right to meddle in the affairs of Birmingham. It's a very long and eloquent letter, but I want to read just a small portion of it so you understand what his timeless statement, "Injustice anywhere is a threat to justice everywhere," actually stands for and the context for which Dr. King wrote it. Dr. King wrote, "I think I should indicate why I'm here in Birmingham. Since I have been influenced by the view which argues against outsiders, since you have been influenced by the view which argues against outsiders coming in, I have the honor of serving as president of the Southern Christian Leadership Conference, an organization operating in every southern state with headquarters in Atlanta, Georgia. Several months ago, the affiliates here in Birmingham ask us to be beyond call to engage in a non-violent direct action program if such were deemed necessary. So I, along with several members of my staff, am here because I was invited here. I am here because I have organizational ties here. Moreover, I am cognizant of the interrelatedness of all communities and states. I cannot sit idly by in Atlanta and not be concerned about what happens in Birmingham. Injustice anywhere is a threat to justice everywhere. We are caught in an inescapable network of mutuality tied in a single garment of destiny. Whatever affects one directly affects all indirectly. Never again can we afford to live with the narrow, provincial, outsider agitator idea. Anyone who lives inside the United States can never be considered an outsider anywhere within its bounds. You deplore the demonstrations taking place in Birmingham, but your statement, I am sorry to say, fails to express a similar concern for the conditions that brought about the demonstrations. I am sure that none of you would want to rest content with the superficial kind of social analysis that deals merely with effects and does not grapple with underlying causes. It is unfortunate that demonstrations are taking place in Birmingham, but it is even more unfortunate that the city's white power structure left the Negro community with no alternative. Birmingham is probably the most thoroughly segregated city in the United States. Its ugly record of brutality is widely known. Negroes have experienced grossly unjust treatment in the courts. There have been more unsolved bombings of Negro homes and churches in Birmingham than in any other city in the nation. These are the hard, brutal facts of the case. On the basis of these conditions, Negro leaders sought to negotiate with the city fathers, but the latter consistently refused to engage in good faith negotiations. So Dr. King's written statement, "Injustice anywhere is a threat to justice everywhere," does not mean that there is some injustice to real water because myself, Mr. Kemp, and Mr. Parker all represent different clients and each have a right to give an opening statement on behalf of our clients. We have all three tried numerous cases where we have sued multiple defendants and we have had one opening statement to multiple defendants. Each having an opening statement because that is the law. So Dr. King's statement, "Injustice anywhere is a threat to justice everywhere," has nothing to do with real water and its claim of unfairness for the three of us having the right under the law to give an opening statement for our separately represented clients. Dr. King's statement is about social injustice, ending racism, and the systematic inequality that has plagued Black Americans, starting with the enslaving of them for hundreds of years at the birth of our nation. Not whether the justice system is being fair to real water for their conscious disregard for the safety of the public and their customers through their deliberate actions of not telling the truth and not following the rules and placing their profits over public safety. Everything I'm about to tell you, we will have proven to be true through the evidence presented during this trial. I told you this at the beginning of my opening statement. Everyone and every company in our country is expected to tell the truth and follow the rules. When it comes to the bottled water we drink, we have the right to the truth, the whole truth, and nothing but the truth. And when it comes to the bottled water we drink, we expect the bottled water companies to tell the truth and follow the rules in our country. And those basic fundamental societal rules are every person and every company, including bottled water companies, are not allowed to endanger the public, and a bottled water company that endangers the public or its customers is responsible and accountable for all the harms and losses they've caused. And the primary concern of the bottled water company should be the safety of the public and their customers when manufacturing, distributing, and selling their bottled water. If a bottled water company manufactures, distributes, or sells unreasonably dangerous or defective bottled water, they and they alone are responsible and accountable for any and all the harms and losses they cause. If a bottled water company consciously disregards the safety of the public and their customers, they must be made an example of in order to discourage other beverage companies from acting similarly. And finally, a bottled water company that places its profits over the public and its customers' safety consciously disregards the safety of the public and its customers. It's really that simple. And finally, a bottled water company, I'm having trouble here with this. And this has been proven, and this trial has proven that Real Water neither told the truth or followed the rules. As you know, Judge Williams has already ruled that Real Water was defective and unreasonably dangerous, and that Real Water caused Lisa King's and the other plaintiffs specific injuries they are claiming. In Lisa King's case, that's severe liver damage, autoimmune hepatitis, and myasthenia gravis. And so the only remaining issues for you to decide are: one, the amount of compensation that Lisa and each of the other plaintiffs should receive, and two, whether punitive or exemplary damages should be found to be appropriate here. So the questions that this jury must answer for Lisa are: what is the amount of money it will take to balance the permanent harms and losses that Lisa King has suffered in the past, and what is the amount of money it will take to balance the permanent harms and losses that Lisa will suffer for the rest of her life? Two, did Real Water act with conscious disregard for the safety of the public? Now, whenever we talk about harms and losses suffered by the plaintiffs, we are talking about damages. So what are the harms and losses caused to Lisa King by Real Water's dangerous defective water containing a highly toxic rocket fuel, hydrazine, and their refusal to investigate the many complaints Real Water received and their failure to do the right testing? Again, this is a photo of Lisa King before she got sick. Incredibly healthy, strong, and vibrant, full of joy, happiness, and excitement about the future. A strong, independent woman who built an extraordinary life for herself and her children, whom she raised on her own without a man. Children who grew up to be intelligent, compassionate, and successful adults. A woman who always met and overcame every challenge that was thrown her way. She graduates with a 4.0 grade point average from high school, with a ton of extracurricular activities, and could have gone to almost any college that she wished. But she got pregnant when she was 16. But that didn't stop her. She has her baby. She still graduates high school on time with a 4.0 GPA and raised her daughter on her own and tirelessly worked to build an incredible, successful career in medical marketing and sales, becoming a regional vice president in charge of 12 states and the highest producer in her company with a high school education. Almost unheard of in this country in these days. When Courtney's father disappeared, she never faltered, complained, or felt sorry for herself. She just fought through it and built a secure life for her children. She met every challenge and conquered all goals, becoming a professional fighter, creating the idea and becoming the star of the show Fight Girls, becoming a sought-after ring announcer and fight commentator, commentating fights for ESPN, NBC, and others. Her accomplishments are, quite frankly, remarkable. And she was a force to be reckoned with. I think you saw that on the stand. And successful at everything she put her mind to. She seemed unstoppable until real water turned her into something she never believed she would be. A victim. A victim of real water manufacturing hydrazine into the water, their water, and convincing her it was the healthiest water there was. As a result of drinking hydrazine in real water, Lisa's liver is permanently damaged, and she developed 2 severe and permanent autoimmune disorders, autoimmune hepatitis and myasthenia gravis. We have proved in this trial that autoimmune hepatitis is a chronic inflammatory liver disease. The disease began when Lisa's immune system began to attack her healthy liver cells with antibodies meant to attack liver infections because of the hydrazine in real water that Lisa drank. This caused Lisa to have chronic inflammation in her liver that led to permanent damage to her liver and could eventually progress to Lisa having liver failure and a liver transplant and even die. Autoimmune hepatitis has caused Lisa severe abdominal pain, extreme nausea, violent vomiting, diarrhea, fatigue, joint pain, skin rashes, and a severely swollen abdomen at times. All symptoms Lisa has suffered for the past 7 years and continues to suffer from today. Lisa had elevated liver enzymes for years until the very end of 2021, and while they have been mostly controlled over the past several years with the URSO prescribed to her by Dr. Gish, remember what Mr. Kemp showed you yesterday through the testimony of Real Water's own expert, that liver enzyme test within normal limits doesn't mean Lisa's liver is not permanently damaged. It is. So she nevertheless has a greater than 50% likelihood that she will relapse and may require a liver transplant, which will significantly reduce the number of years she will live.
Okay, and based upon these articles, you would agree that as time goes on, there is a greater likelihood that both Ms. Bordenave and Ms. King will suffer relapse of autoimmune hepatitis, correct?
Yeah, according to that reference, yes.
Isn't it true
isn't it true that you cannot rule out in the future that Lisa could possibly have a require a liver transplant, correct?
I cannot rule it out.
And we have also proven in this trial that real water caused Lisa to develop myasthenia gravis, a chronic autoimmune disease caused by the hydrazine in real water, which in turn caused Lisa's immune system to mistakenly attack proteins in her neuromuscular junction where her nerves connect to her muscles. This has resulted in Lisa having skeletal muscle weakness, meaning weakness in her muscles that connect to the bones, and the most commonly targeted muscles, which were all targeted among others in Lisa, are the muscles in the eyes, face, neck, spine, arms, and legs. Myasthenia gravis caused Lisa to have severe weakness of the bulbar muscles, which are the group of muscles in her head and neck responsible for speech, swallowing, chewing, and jaw movement, as well as Lisa's respiratory muscles, all symptoms Lisa has suffered from over the past 7 years and continues to suffer from, and will for the remainder of her life. And because these symptoms are causing Lisa to have respiratory weakness, she may eventually end up on a ventilator or worse, not make it to a medical facility who can treat her in time and die. Myasthenia gravis affects Lisa's ability to do things like chew, swallow, talk, and walk, and has caused her to experience and likely to continue to experience tremors, slurred speech, blurred or double vision, droopy eyelids, and limited facial expressions. And because, as Dr. Mahajan told us, myasthenia gravis is a progressive disease, and Lisa's symptoms will only get worse, not better.
All right, thank you. Have the symptoms you just taken us through been persistent symptoms Lisa has experienced since being diagnosed with myasthenia gravis?
They've been persistent and progressive.
And progressive, getting worse?
Yes.
Okay.
Myasthenia gravis caused Lisa to have difficulty walking, climbing stairs, getting up from chairs, and raising her arms above her head at times. And again, these symptoms will only get worse as time goes on, never better, as confirmed by Dr. Mahajan. Lisa experiences worsening of symptoms in the form of myasthenia gravis flare-ups or exacerbations, which sends her to the hospital for IVIG treatments triggered by infection, emotional distress, which we know and defendants have stipulated that Lisa suffers from, surgeries, and medication. MG affects Lisa's neuromuscular junction and can result in significant morbidity and even death. So along with all of Lisa's symptoms, she could have significant morbidity and even death from MG. Lisa developed all of these symptoms within 2 years of the disease onset in her, and she continues to experience all of these symptoms, some at different times, many all at once. But which Dr. Mahajan has told us will only get worse. And that is not speculation, ladies and gentlemen, that is an uncontroverted fact in this case. Over the last less than 5.5 years, Lisa has endured 21 IVIG rounds for her MG, and as you know from Dr. Mahajan, Lisa's neurologist, she will require 2 rounds of IVIG treatments monthly or 24 times a year for the remainder of her life. And because Lisa will be receiving IVI treatment so often, she will require that an intravenous access port called a port be permanently placed in her breast, which brings its own complications and emotional issues, aside from how unattractive she thinks that will make her feel. And on top of everything else she has endured and will have to endure for the remainder of her life. And this port will also need to be replaced every 5 years, and that doesn't even consider if she gets an infection from it. As we have learned, each IVIG preparation is made from the pooled plasma of an average of 8,000 donors.
Are you aware, Dr. Alsina, that each IVIG preparation for one round of IVIG treatment is made from the pooled plasma of an average of 8,000 blood donors?
That sounds correct.
Okay. And what is the IVG made from? How does it?
Yeah, so the IVIG is actually it's from people that donate plasma, basically. So it's the plasma is gathered, and basically it's put through a stringent kind of clearing process, and it's isolated from a pool of on average 8,000 donors, basically. So we pool
8,000 blood donors.
Correct.
Donate their plasma.
Yes.
Okay.
Again, that's not speculation. That's an uncontroverted fact in this case. Because it is derived from donor blood, IVIG carries with it the real risk to Lisa of transmitting infections and bloodborne diseases to her. And while screening techniques are used, it is impossible to completely eliminate all possible viral infections from IVIG preparations. And although IVIG is extracted from plasma obtained from donors screened for infections, the potential for transmission of infectious diseases, including certain viral diseases such as HIV, hepatitis B, and what Dr. Hamajan told us is commonly referred to as mad cow disease, which is a neurodegenerative condition caused by faulty proteins that leads to mental deterioration, involuntary muscle movement, and other central nervous system deficits cannot be totally eliminated. All of these additional diseases, Lisa is genuinely at risk for.
And are you aware that since it's derived from donor blood, IVIG carries the potential risk of transmitting infectious and bloodborne diseases?
That's a potential risk. They're tested, but there's always a potential risk of transmission.
And so, yeah, I understand you're aware that they're tested, and while their screening techniques are used, it is impossible to completely eliminate all possible infections from IVIG preparation, correct?
Correct.
Does IVIG carry a risk of transmitting a viral infection via the donor's antibodies it contains?
So the risks of viruses like HIV, hepatitis B, even something called prion disease, Creutzfeldt-Jakob disease, CKJ can be transmitted.
What is that?
It's something commonly known as mad cow disease. It's a prion disease that can actually be transmitted as well. It causes neurological weakness, a quick mental decline, and usually demise for these patients.
Demise, death.
Death.
Again, that's not speculation. That's an uncontroverted fact in this case. And it doesn't take a genius to know that the more and more donors' blood plasma that enters Lisa's bloodstream, the higher the risk gets that Lisa will have one of these diseases transferred to her on top of her two autoimmune diseases. Lisa has had 21 rounds of IVIG treatment total to date, with an average of 8,000 donors per each round, which equals 168,000 antibodies in her blood already from donors, different donors. And according to Lisa's neurologist, Dr. Mahajan, she will require 24 IVIG treatments every year for the remainder of her life. And this is not speculation, ladies and gentlemen. This is an uncontroverted fact in this case. And if we assume Lisa doesn't die from this, then over the next 34.3 years, Lisa will have an additional 6,585,600 different additional donors, antibodies, enter her blood. Plus the 168,000 donors that's already entered her blood, is a total of nearly 7 million different donors' blood over her lifetime. Again, it doesn't take a genius to know that her risk of having another blood-borne disease transferred to her from one of these IVIG treatments goes up and up with each treatment. And nearly all of Lisa's myasthenia gravis symptoms continue today. You have heard about the weakness in her legs that she has when she has an MG flare-up or exacerbation that is so severe, sometimes she can't even walk to her own mailbox or stand in line to mail a package. She has continual throat tightening and closing, which frightens her each time it happens because she has been told by Dr. Mahajan that it is the most common way people with myasthenia gravis die, because if she doesn't get to a medical facility that can treat her in time, she will die. Again, this is not speculation, ladies and gentlemen. This is uncontroverted facts in this case. And this is, her neck stiffness and weakness continues, along with her difficulty speaking or slurred speech intermittently, admittedly, with no idea when it might occur, which is incredibly embarrassing for her. And so Lisa requires ongoing treatment for the remainder of her life to manage these conditions and to simply try to stay alive. And again, all these symptoms that she has had and will continue to have, they're not speculation. These are uncontroverted facts in this case. Both Lisa's autoimmune hepatitis and myasthenia gravis are not curable. They can only be managed with medication and IVIG treatments. Again, not speculation, but uncontroverted facts. Further, MG is a progressive disease, and it will only get worse. And she understands she will likely eventually lose her mobility and end up on a walker or wheelchair like the other patients she sees at her IVIG treatments with MG that have had the disease longer than her. Not speculation, but uncontroverted facts in this case. It has not been disputed, and it has not been disputed by anyone in this case, that Lisa has both of these horrific diseases caused by Real Water's refusal to tell the truth and follow the rules, and neither is curable. So she will endure them for the remainder of her life, however long that ends up being. Not speculation, uncontroverted facts in this case. And it is likely that Lisa will have a relapse, and because she has autoimmune hepatitis, the medical literature in fact says that it's likely she will. Mr. Parker laid that out for you in great detail. And again, this is not speculation, but an uncontroverted fact in this case. And we have learned that the average liver transplant patient only lives for an average of 12 to 15 years after the transplant. And it can often be much shorter than that.
Now, are you aware that Dr. Hudson testified under oath that it is the median survival after a liver transplant is 12 to 13 years?
There's different data. I mean, depends where you get the data from. I've looked at this many, many times, Mr. Rebecca. I've done a lot of cases about
You
this.
think Dr. Hudson hasn't looked at this many, many times?
No, I didn't say that.
Okay.
But I'm up to speed with it.
Okay, do you think Dr. Hudson's up to speed to it as well?
I think he's up to speed too. But I think it's, okay, 12 to 15 years and then
Or 12 to 13 years, right?
Could be 12, 13, 15, it could be.
So we can agree on 12 to 15, right?
Yeah.
Okay.
So she may have a significantly shorter life if this happens. And as Mr. Parker said so eloquently, we can hope for the best, but what do the smartest people do? They prepare for the worst, right? And for the first time, for the very first time in Lisa's life, she is afraid of not her own unknown future, like many of Mr. Kemp's clients, but in her case, her known future, and what will come next, and how much worse she will get, because she will get worse. There's no doubt about that. And worries whether she even will have that many years left in her life. And I think you know now how much Lisa values her independence. She's been a fiercely independent woman her entire life. And I think you understand that Lisa's worst fear has always been to be dependent on someone else. And that, unfortunately, is now a foregone conclusion for her. As Judge Williams told you at the beginning of this case, and has told you throughout this trial, and told you again yesterday in the jury instructions, it is your duty to follow the instructions that Judge Williams gave you. Even if you have an opinion that the law should be something else, you still have to follow the instructions in order to keep your oath to the court. And that's what jury instruction 1 provides. It's your duty as jurors to follow these instructions, regardless of any opinion you may have as to what the law ought to be. It would be a violation of your oath to base a verdict upon any other view of the law than that given in the instructions of the court. And jury instructions 8 and 9 say that you must consider and base your decisions only on the evidence that was presented to you in this courtroom. No outside information is allowed. And jury instruction 23 instructs you on what you must consider, and only what you may consider in your decision of how much money will be required to balance the harms and losses that Real Water inflicted upon Lisa. The law says you have to compensate Lisa for the damages she has suffered. You have to compensate her. And for those damages, she will suffer in the future. So what does compensate actually mean? And what does it not mean? It's a very old word from the Latin, dating back to like 1600, meaning to balance or equalize, to make things weigh the same, hang at the same level. If one side is heavier, the scales do not balance, so it's uncompensated. And your most important task regarding damages is to know what counts as part of the weight and what doesn't, or what you can place on the scales and what you can't. If this scale holds Lisa's harms and losses, what are you allowed to put in the other side to balance it? Outside reasons are not allowed. You must base your decision only on the jury instructions and what you have heard in this courtroom and seen. Think of a person who has a job. That's the way I like to analyze this. Think of a person who has a job. Her work goes into the scale on one side. The longer she works, the heavier the scale and the lower it gets. Her boss must pay the worker. He must compensate her. The boss must balance the work with money on the scale to equalize. And the more the boss puts on the scale, the other scale, the closer he comes to compensating her. Balancing the work with an equal amount of money. If the boss pays her too little, the worker is undercompensated. So compensation means to balance, to equalize. The boss is not allowed to lower her compensation by putting outside reasons into either scale. For example, the boss must not say, I think I'll give her less money than it takes to balance her work because her living expenses are low, so more money won't really do her any good. That's an outside reason. It's not allowed. It makes no difference how low the worker's living expenses are. The boss has to pay her based on the amount of work she did. So there is no deductions for any outside reason. The boss cannot say, paying enough money to balance her work will force us to raise prices, so we will pay her half. Or it's more money than anyone needs. Or this worker is used to living on a very little money, so she doesn't need more. Or it might seem like a windfall. Or her husband also works, so she doesn't need as much. Or if we pay her what is owed, it will put us out of business. The boss is not even allowed to lower her pay because she has some other source of income. And the boss certainly cannot lower her compensation because he feels sorry for the owner of the company having to pay the right amount. Or because he's worried it might hurt the company or the company can't pay it. The worker did the work. She is entitled to full compensation. Not 3/4, not 2/3, not 1/2. Her full compensation. It's the same thing in trial. The very same. So no lowering Lisa's compensation for any outside reason or any of the other plaintiffs. You just substitute harms and losses for work for Lisa and each of the other plaintiffs. The law in every courtroom in America says nothing goes on the scale but all the harms and losses caused by the defendant on one side and enough money on the other side to compensate, to to balance the scale with the harms and losses. So no outside reasons are allowed. And your most important job is to make sure everyone follows that law. So on this scale goes the amount of money that balances Lisa's harms and losses caused by real water. No outside reasons can lower it. The judge has given you jury instruction 23 explaining compensation. Jury instruction 23 tells you in determining the amount of losses suffered by each plaintiff, you will take into consideration the nature of the injuries or damage you believe from the evidence each plaintiff sustained, and you will decide upon a sum of money sufficient to reasonably and fairly compensate each plaintiff. Jury instruction 23 tells you to put in the verdict the amount of money it takes to compensate or balance, match, equal the losses and harms caused by real water. Jury instruction 23 does not tell you to take anything else into account, as you are not allowed to. So no outside reasons. The judge did not tell you in this jury instruction to lower your verdict on the grounds that the full amount might not do any good, or might be too much money for one person, or might drive up prices, or the company might not be able to pay it. Those are outside reasons. They're not allowed. Or whether the money will make her suffering go away, or be more money than Lisa ever would have had, or more than she could ever spend. One outside reason is whether the right amount of money to balance with Lisa's harms and losses might change Lisa's lifestyle. But it was Real Water's defective product that changed Lisa's lifestyle. So even if equalizing Lisa's harms and losses with the right amount of money does change Lisa's lifestyle, it just makes up for the lifestyle Real Water took from her. You do not see any jury instructions saying to lower the amount of the verdict to avoid changing the plaintiff's lifestyle, because that would be an outside reason. The law does not allow it. Outside reasons have nothing to do with compensation. So jurors must not let other jurors take any of those outside reasons into account. Of course, we all want to use our own beliefs and concerns, but as jurors, we need the strength and wisdom and courage to keep outside reasons outside. The law allows no outside opinions, outside politics, or any other outside reasons. And we have to obey the law that is the law right now, not what we might prefer the law to be. You as jurors have no more important job than to adhere to the law as it is right now. So in deliberations, if a juror wants to use an outside reason, remind him or her only harms and losses and money go on the scale. The juror lowers the verdict, the jury lowers the verdict for any outside reasons, the law's purpose will be undermined. And outside reasons undermine the purpose of the law. What is the purpose of the law? The purpose of the law here is society's only way of making companies who make and sell defective, dangerous products meet their responsibility by fully balancing, compensating, and making up for the harms and losses they caused. If a verdict is for less than the full and fair amount, that equalizes the harm. If your verdict is anything less than the full measure of the harms and losses as Lisa feels them, if you take any outside reason into account, even just a little, then Real Water walks away without having to meet its responsibility. When you go back to the jury room, you're going to find that an interesting process happens. Mr. Kemp and I have both been talking to jurors for 37 years or more now, both this way and after their verdicts. And you're going to find that when you get back there, after we have given you what we believe Lisa has earned and the other plaintiffs here have earned by way of damages, that there might be one or two jurors who will say, yes, Lisa and the other plaintiffs here proved those damages, but let's compromise. Let's give her something less. Let's give them something less. Let's do some trading. When somebody suggests that to you back there, and you are one of our friends, why don't you ask them one question? Why should I compromise? Why should I do some trading with this woman's future? It isn't because this senseless action was not caused by Real Water's unreasonably dangerous, defective product and their outrageous actions. The responsibility and the causation of Lisa's diseases has been proven already, and the judge has ordered that they are established. So we would ask you that you do not do any trading with Lisa or any of the other plaintiffs' future. The evidence and the law demand that she and the other plaintiffs be compensated, not compromised. It is easy for one to say, and I understand this, it is easy for one to say that Lisa's and the other victims of Real Water here, their problems are their own. But we know from the evidence that what happened to Lisa and the other plaintiffs and the effects that it has had on her and the other plaintiffs could happen to any member of anyone's family, anyone's daughter or sister, anyone's spouse or friend. And our only protection against this type of reprehensible conduct and dangerous and defective products is knowledge that we can find shelter, we can find justice in the law. And the one thing that we should have learned from history as well as from our daily lives is that our security, our liberty, our health, and our pursuit of happiness are only as secure as our neighbors will make them. A corporation who irresponsibly brings about injury to another, such as this, is as much a concern to me as the person who is injured. If a case was brought because a bottled water company's plant was destroyed as a result of another in an explosion or fire, and it had a value, another's actions, I should say, and it had a value of over $200 million, would a jury, for a moment, diminish the bottled water company's harms and losses because of the fact the harms and losses are so much, $200 million, even though that's the value of the building? Of course no jury would do that. And pain, disease, and loss of life's pleasures is something that a person lives with, ladies and gentlemen, because she cannot hire a substitute to take her place. If someone could suffer for those in pain with an incurable, progressive, chronic disease, what would the hourly rate be? In cases of an incurable, progressive, chronic disease, do you think a substitute could even be found, regardless of the salary that was offered? Even if someone could be found, how long would she be willing to work? The person who hires on for a single day at $50,000 knows that her suffering is not infinite. She can see the light at the end of the tunnel. What would happen to that person were she left to suffer for the rest of her life? Would that $50,000 a day suddenly become an unfair trade? Would it prove fair and reasonable compensation for a lifetime of suffering? The child has a painful disease, and the pain can only be alleviated by expensive medication. What is the price of his pain? The child suffers not from the lack of sympathy, but from a lack of compensation. The compensation he needs is whatever is required to relieve his pain. What parent could ever deny his or her child this simple relief because the medication was too costly? Can you imagine the little boy's parents sitting with him one morning, almost feeling his pain themselves, and saying to their son, "Your medicine is just too expensive, that we think it's better use of the money would be to is in a practical investment, such as common stocks, savings, or bonds." No parent would do that. So who among us has ever met a person who would accept a lifetime of suffering in return for great wealth or success? The poorest man will not part with his health for money, but the richest man would gladly part with all his wealth for health. All of us live for the enjoyment of life, right? Don't we? We work, strive, plan, dream, create so we can have the time and place and loved ones with whom we can enjoy life's pleasures and life's riches. What person lives solely for the sake of existence? This was what God intended us to be. Human beings never would have survived our early beginnings. God tells us to go forth and prosper. He gave us the uniquely human emotions of love, joy, and happiness. God doesn't want any of us, his children, to suffer. Lincoln was talking about this when he said the value of the enjoyment of life, when he said, in the end, it's not the years in your life that count. It's the life in your years. Nelson Mandela echoed this profound statement a century later when he said, "There is no passion to be found in living a life that is less than the one you were once capable of living." Men and women work, strive, sacrifice, and endure in the name of what we call the enjoyment of life. Most citizens recognize that the neighbor who has been injured or caused to suffer debilitating disease through the defective product or actions of a company is entitled to just compensation. But when the painful and heart-wrenching effects of the injury or disease bring about a loss of enjoyment of life, the concept of just compensation becomes clouded or obscured sometimes. Our founding fathers, nearly 250 years ago, 1 year short of it, pronounced in our Declaration of Independence that all men are created equal and that they are endowed by their Creator with certain unalienable rights. That among these are life, liberty, and the pursuit of happiness. Good health can never ensure happiness, but pain, disease, and physical limitation, like a dreaded virus, will always attach to that part of the human heart where happiness and enjoyment of life reside. What is life without pleasure, ladies and gentlemen? It is a biological existence. Nothing more, nothing less. And that is not what God intended for us. It is as sad as a flower that will never bloom, or a bird that will never fly. It is a simple recipe for torturing a soul. A Stephen King who could not write, a Beyonce who could not sing or dance, a Picasso who could not paint, and a Martin Luther King who could not preach or speak. They would all exist, but would they truly live? So how should we view the assessment of damages for an injury that deprives a neighbor or a friend of the enjoyment of life? Life without the ability to enjoy and participate in things that gave us pleasure or give us pleasure and satisfaction is like a marriage without love, like a child without spunk, energy, or imagination, like a family without a loving home. A wise teacher once asked his students, what's the saddest thing they had ever seen? One of his students answered that the saddest thing was a bird that could not fly. Another suggested a young deer that could not walk or run. Finally, after hearing all the responses from his students, the teacher answered that the saddest thing in the world is a person without hope. Remove a person's hope, and you cast her into a world full of fear and worry. Troubled waters that the law calls mental suffering. And think of how often we express in our daily wishes the hope that others may be free from pain. For instance, such as, have a nice day, have a safe trip, or drive safely. These are all expressions of our wishes of continued health and freedom from pain. On anniversaries and birthdays, we say many happy returns. At weddings, the common wish is for a long and happy life together. Very seldom do we wish for anyone to have great wealth or fortune. And this is because we all silently recognize that health, well-being, and freedom from pain and disability are much more important and valuable than any monetary or financial reward. Time stands still for those who suffer, ladies and gentlemen. It literally stands still. It's easy to quantify the suffering of another in time, but for the person suffering, a simple measurement of time cannot begin to express the extent of her anguish. It's not a matter of months or years of suffering, but of thousands of days and nights with scarcely a noticeable beginning or end. A person who suffers lives their days and nights a minute at a time, counting time by the clock instead of the calendar. Time is often considered an absolute, but it's not. A minute, 60 seconds can be a blinking of an eye or an eternity. There are countless examples of this. Reading a good book, watching an interesting TV show, playing a round of golf or a match of pickleball, which I wouldn't recommend because you get hurt doing that. I've done it. Have we all not noticed how fast time seems to fly by when we're doing things we enjoy? Watching an exciting movie, a sporting event that captures our attention never seems to last 2 or 3 hours. After a couple of days off for the weekend, we return to our jobs and it seems the weekend just flew by. Yet when we face tragedy, time stands still. A minute of suffering does not pass like a minute engulfed in our favorite show or watching an exciting football game or a good movie. Minutes of suffering become hours, hours of suffering become days, and days of suffering become eternities. For nearly 7 years, Lisa has been paying the price of Real Water's dangerous, defective product and reprehensible conduct. Her entire future was mortgaged by Real Water. Every minute of every hour of every day for the rest of her life will be spent in retiring that debt. In addition to the injuries, there is another consideration that is equally important in your formula. That is the time over which this anguish and agony will be experienced by Lisa. Lisa's anguish, Lisa's mental distress and worry, Lisa's loss of enjoyment of life, loss of enjoyment of many aspects of her life, and the time over which it will occur. What has Lisa's life been like since Real Water inflicted its damage on her? If we multiply 7 years by the number of days in a year and hours in a day and minutes in a day, you will translate this into 255 days, 61,320 hours, and 3,679,200,000 minutes. What approach could be more fair than for you to consider the nature and extent of her injuries, her suffering, her anxiety, and her mental distress and worry, and the time over which this will occur. We only suggest that in evaluating this element of damages, it is appropriate that you view it the way she, Lisa, must experience it on a minute-by-minute basis. For the last 7 years, Lisa has endured pain, suffering, endless medical treatments, along with countless medical procedures and hospitalizations, 21 rounds of IVIG treatments, and you've heard how those make her feel. With 168,000 blood donors, blood entering her blood, and the risk that brings, post-traumatic stress disorder, worry about her future, and how much worse she will get. 61,320 hours of pain and suffering and loss of most of the pleasures in life she enjoys. The anxiety of how much longer it will be before she loses her mobility, like the other patients with myasthenia gravis. She sees at her IVIG treatments and how they are. And the mental anguish of knowing she has lost her strength, her independence, and eventually will be totally dependent on others. And 3,000,000 679,200 minutes of worry and fear and mental anguish about her future and how much worse she will get, because she will get worse. That's an uncontroverted fact. Until she leaves this world for the better place we all hope to go. According to the life tables, Lisa, who is now 52 years of age, has a reasonable life expectancy remaining of 34.3 years. You have heard from her doctors that there is no cure for her autoimmune diseases. She is forever left with the suffering effects of these diseases. When we talk about years in the abstract, it is a difficult concept to understand what length of time we are talking about. But to understand the magnitude of this period of time, think about it this way. I'm expecting my first grandchild in August. That redhead sitting back there is my beautiful daughter, who's a fifth-year lawyer in my office. I've had to wait a long time for this. But her child, her daughter, she's gonna have a girl, her daughter will have gone to and graduated from elementary school, middle school, high school, college, maybe law school if she follows in her mother's and her grandparents' footsteps, practiced law for 9 years, married and had a child of her own. And her child may be in school by the time Lisa dies and is finally freed from the effects of these diseases. I give you this example only to help you understand the period of time we're talking about under which Lisa will be condemned to a life of suffering, to a loss of life's pleasures, the pleasures she enjoyed. So what is Lisa's future if she lives to be over 86 years old? If you multiply 34.3 years for life expectancy by the number of days in the year and hours in the day and minutes in the day, you will translate this into 12,520 days, 300,480 hours, and 18,028,080 minutes, under which Lisa will be condemned to a life of suffering from these diseases and the losses of many of her life's pleasures. That is the time over which her suffering and loss of enjoyment of life will be experienced by Lisa. And so what approach could be more fair than for you to consider the nature and extent of Lisa's injuries, 34.3 years of physical and mental pain, of endless medical appointments, 823 more IVIG treatments, 7 million blood donors, blood entering Lisa's bloodstream, 12,500 days of anguish, disability, loss of her mobility, loss of her independence, and loss of her identity. This is not speculation, ladies and gentlemen. This is uncontroverted facts in this case. 300,480 hours of the loss of the enjoyment of the life she once had and she had worked so hard to build. 18,028,080 minutes of despair, anguish, mental suffering, post-traumatic stress disorder and utter heartbreak for losing the life she once had without any hope that it will ever, ever return. We suggest this is the only fair way to look at Lisa's harms and losses, the way she has experienced them over the past 7 years and the way she will experience them over the next 34.3 years. 1 minute at a time. And we could argue that to balance, to fully compensate her for the harms and losses she has already experienced over the last 7 years, that $8.16 per minute is the minimum amount that is required. To balance with her harms and losses real water inflicted upon her, and if you multiply $8.16 by 3,678,200 minutes, that will balance Lisa's harms and losses she has suffered over the last 7 years with $30,022,272. And of course, the court has already found that Lisa has $904,664.15 in past medical expenses. And we would argue that to balance, to fully compensate her for the harms and losses she will experience over the next 34.3 years, that $6.66 per minute is the minimum amount that is required to accomplish that. And if you multiply $6.66 times 18,280,080 minutes, that will balance Lisa's harms and losses she will suffer over the next 34.3 years with $120,067,013. Dr. Stephan Sands, plaintiff's expert neurologist, evaluated Lisa and determined the cost for future neuropsychological evaluations and services and the cost for future psychological evaluations and services. Future neuropsychological evaluations range from $5,000 to $10,000 per evaluation, with an average of $7,500. Future neuropsychological services are $200 to $250 per session and recommended 1 time per week for 4 years. So $225 times 52 weeks times 4 years equals $46,800. Future psychological evaluation ranges between $1,500 and $2,000 with an average of $1,750. Future psychological services range from $300 to $400 per session. And there has been no evidence offered by Real Water that because of Lisa's severe life-threatening medical conditions and PTSD, that she will not require psychological therapy treatments for life. So $350, the average, times 52 weeks, times 34.3 years equals $624,266. We add everything up for her psychological treatment and evaluations. Lisa's total neuropsychological and psychological services will cost $680,316. Adding Lisa's future neuropsychological I just looked at that. Plus the $12 million you have been told in future medical expenses that Real Water has agreed and stipulated that she requires. So ladies and gentlemen, after you return the verdict, you will go, and I'm almost done, I know it's been a long time, but after you return with your verdict, you will go back to your family and friends. The court will go on to another trial, and the attorneys will go on to our next case. And you will probably stop thinking about Lisa at some point, about what happened to Lisa. And you won't think about it as she goes on for the next 34 plus years, suffering with 2 autoimmune diseases that we know will only get worse. And years from now, you might have a thought about Lisa. And you might say, I wonder how she is doing. I wonder how much worse she got. I wonder if she now has to use a cane, a walker, or a wheelchair. I wonder how much worse her suffering got. And wonder is all you will be able to do. Since Mr. Kemp and Mr. Parker is all you will be able to do, and because Lisa, she can't come back here in 10 or 15 years when her suffering has gotten much worse as predicted and ask another jury for another verdict of damages for her. This jury, you are Lisa's only chance at justice for what's been done to her. You're it. Since Mr. Kemp and Mr. Parker have covered in detail why you should check the box on the verdict form that punitive or exemplary damages are required here, I'm not going to belabor the point with you. However, I do want to show you a summary of most of the points they both covered very well. They did know Real Water, did no general non-targeted screening test that would have discovered hydrazine in their water before starting sales, and failed to do general screening tests after multiple customer complaints. Real Water did not perform GCMS testing after customer complaints of a gasoline-like substance. Real Water only performed bacterial tests instead of GCMS tests that would detect all toxins, including hydrazine, and had almost zero quality control, and knew of serious customer service complaints and failed to investigate. This case screams out for punitive and exemplary damages, ladies and gentlemen. I think I talked about that, so I'm going to say thank you and sit down.
Thank you, Mr. Everett. Now, your approach. Okay, ladies and gentlemen, what we're going to do, we're going to recess for the evening. Tomorrow we'll finish up with the defense closing arguments starting at 10:30. And what I would try to do is try to get here around 10:15, because we'll want to get started at 10:30 sharp, unless I have cases that slow me down. I don't think I will, because they do have, my court starts at 9 o'clock. So we'll try to get going at 10:30. Remember, you're admonished not to converse amongst yourselves with anyone else on any subject matter connected with this case, or to read, watch, or listen to the report of or comment on any person connected with this case or matter by any medium of information, including without limitations, newspaper, television, radio, social media. Remember the prohibition. And last but not least, do not form or express an opinion on any subject matter connected with the Trump or the cause of science. Hit here on Tuesday.
Yes, Your Honor. All rise to support your jury. Looking forward to it.
And I don't know if we can do this, but I'm hoping that tomorrow morning, since they're closing, maybe we can do a rebuttal before lunch.
I wouldn't count on that, Judge. I like how optimistic you are.
Yeah. But we can have an aspirational vote.
That's it.
Thanks, Judge.
Okay.